Welcome, viewers. The purpose of this video is strictly educational, to provide a rigorous, objective academic lecture on the legal mechanisms, executive procedures, and structural dynamics of the Global Magnitsky Sanctions framework under American foreign policy and international law. This presentation is designed purely for political science and diplomatic study and does not target, refer to, or slander any specific individual, organization, or political entity. If you find this analysis insightful, please consider subscribing, liking, and sharing this video to support the production of in-depth, research-based international relations content. Good day. Today, we will examine the Global Magnitsky Sanctions, one of the most critical mechanisms for understanding the contemporary international political and financial order, focusing specifically on its legal structure and the exact administrative procedures through which the President of the United States executes it. This system is far more than a simple tool for diplomatic leverage. It is widely recognized as a sophisticated hybrid instrument that integrates U.S. foreign policy, the international financial architecture, and global human rights policy. Consequently, political and economic elites around the world view its application with immense sensitivity. Before diving deeper, one fundamental point must be clarified. The Global Magnitsky Human Rights Accountability Act was not enacted to target any specific nation or political faction arbitrarily. Rather, it established a standardized legal framework enabling the U.S. government to impose sanctions against foreign individuals or entities determined to be involved in serious human rights abuses or significant corruption. Therefore, the actual imposition of sanctions is never decided by political rhetoric alone. It requires prolonged intelligence gathering, extensive legal review, and rigorous interagency coordination before the final determination is rendered by the U.S. executive branch. A question frequently arises in diplomatic and policy circles. Must the President of the United States seek congressional approval every time they wish to enforce Global Magnitsky sanctions? To put it plainly, no, because the U.S. Congress has codifying legislation that rendered the Global Magnitsky framework permanent. The President is not required to obtain congressional authorization on a case-by-case basis. In structural terms, Congress enacted the statutory authority and delegated it to the executive, leaving the operational exercise of that authority as an inherent prerogative of the executive branch. This distinction is crucial. The legislative branch forged the sword and handed it to the President. The executive branch alone decides when and how to unsheath it. Thus, the actual implementation of sanctions operates strictly under the constitutional executive authority of the President. At the core of this authority lies the President's extraordinary economic powers, derived from statutory frameworks, such as the International Emergency Economic Powers Act, IEEPA. Utilizing these pre-established authorities, the President can initiate sanctions via executive orders whenever a foreign national is deemed responsible for gross human rights violations or corruption. The hallmark of this mechanism is operational agility. There is no need to pass new legislation or await a parliamentary vote. Once internal executive consultations are complete, the administration possesses the structural capability to execute sanctions immediately through the executive order framework. This structural swiftness is precisely why the international community views U.S. sanctions policy as having an exceptionally high level of enforcement efficacy. Furthermore, because the executive branch maintains established administrative frameworks under relevant executive orders, it can enforce actions simply by designating and adding new individuals or entities to existing sanction lists. From the perspective of potential targets, this creates significant unpredictability regarding precisely when, where, or how sanctions might be announced. International finance operates fundamentally on trust. When that trust is legally severed, financial transactions are instantaneously disrupted. This structural unpredictability serves as a core deterrent factor, greatly enhancing the overall strategic leverage of global sanctions. Does this mean Congress plays no role whatsoever? Not at all. However, Congress operates as an oversight body rather than an approving authority. Foreign Relations Committees in both the U.S. Senate and the House of Representatives hold the statutory power to request investigations into specific individuals or formally urge sanctions reviews. Yet these actions constitute formal requests for executive review, not binding directives to the President. While statutory provisions may obligate the President to report back to Congress on investigative findings within a specified time frame, the ultimate decision on whether to impose sanctions remains exclusively with the executive branch. This reflects the foundational principle of separation of powers under the U.S. Constitution. The legislature monitors and checks, while the executive enforces. Is a decision to impose Global Magnitsky Sanctions reached overnight? Absolutely not. On the contrary, the process is notoriously rigorous and often time-consuming. Prior to a formal announcement, a multi-tiered review process, taking anywhere from several months to well over a year, is routinely conducted. Phase 1, information gathering. The U.S. Department of State and the Department of the Treasury systematically collect and analyze data. This involves synthesizing reports from international organizations, non-governmental organizations, NGOs, investigative media, diplomatic channels, and various government agencies. Where appropriate, classified intelligence gathered by intelligence agencies is also evaluated under strict statutory guidelines. Phase 2, interagency coordination. At this stage, the matter transcends foreign policy to encompass a simultaneous review of law, economics, diplomacy, and national security. The State Department analyzes potential diplomatic ramifications. The Treasury Department evaluates the potential impact on the international financial system, and the Department of Justice verifies legal sufficiency and statutory compliance. During this phase, the target's identity, affiliated corporate entities, financial transactions, corporate structures, and publicly verifiable assets are exhaustively cross-examined. Phase 3, drafting the legal package. In this phase, government attorneys compile evidentiary files, robust enough to withstand potential administrative challenges or judicial proceedings. The U.S. Executive branch rarely issues sanctions based on unverified allegations. It enforces a strict administrative standard to ensure all statutory thresholds are satisfied. Thus, international sanctions involve far more complex administrative due process than is generally perceived by external observers. Phase 4, presidential authorization and designation. Upon completion of all interagency reviews, the President makes the final determination. Following presidential authorization, the Office of Foreign Assets, Control OFAC under the Department of the Treasury, updates its designated sanctions list, such as the specially designated nationals list. The sanctions take immediate legal effect upon publication, triggering compliance obligations for global financial institutions and multinational corporations worldwide. To be sure, exceptions to this standard timeline exist. In cases where an issue presents an acute threat to national security, expedited procedures may be implemented far faster than the standard multi-month review. Even under such expedited timelines, however, internal legal reviews and strategic policy assessments within the executive branch remain mandatory. Not all cases are handled uniformly. Throughout this process, multiple U.S. agencies execute distinct, specialized functions. The Department of the Treasury oversees financial and banking sanctions. The Department of State assesses diplomatic impacts and international relations. The Department of Justice ensures rigorous statutory and legal compliance. Relevant intelligence and law enforcement agencies provide specialized analytical and investigative support within their respective legal mandates. Therefore, it is most accurate to understand the Global Magnitsky framework, not as an arbitrary decision by a single agency, but as an integrated multi-agency decision-making matrix within the U.S. government. In conclusion, the core essence of the Global Magnitsky Sanctions system lies not merely in the act of penalization itself, but in how it unifies international finance, diplomacy, law, intelligence, and national security into a single, cohesive policy architecture. It stands as one of several sophisticated tools utilized by the United States to address human rights abuses and transnational corruption within the international arena. If there is one central takeaway from today's lecture, it is this: Global Magnitsky Sanctions are not political declarations, but established administrative measures operating through codified statutory authority and rigorous government review protocols. Their application depends entirely on specific facts, verifiable evidence, and strategic policy determinations by the U.S. executive branch, meaning no two cases are treated identically. Understanding the structural mechanics of this framework provides an indispensable foundation for analyzing contemporary international politics, international law, and the global financial order. Thank you for watching. If you wish to deepen your understanding of international politics, global diplomacy, and the structural mechanics of the world financial order, please stay connected with this channel. Your subscriptions, likes, and shares are vital in helping us continue to produce rigorous, high-quality, scholarly content. Thank you, and I look forward to our next discussion.